Yes.
Lords, there are two appeals before the court. I appear with Mr. Skinner for the Secretary of State in both appeals. Mr. Hawken and Ms. Farron appear for Mr. Hirtie. Mr. Kariko Casey and Mr. Usman appear for Mr. Lewis.
Yes. And we've had the email exchange about the structure of the hearing.
Yes.
And is that all right? I think we'd rather keep them separate from the point of view of submissions. I appreciate that in making your submissions in Hirtie, you might cover some of the legislation and points that you would then raise in Lewis, so there won't be any need to duplicate them, obviously. But
that is the change, yes.
Thank you.
Good. So, my lords, I'm sure you have picked from the papers that Mr. Hirtie is a foreign criminal. He came to the UK from Romania and was granted leave to remain under the EU settlement scheme until 2026. He has a partner and they have two children born in 2019 and 2022. They are also Romanian nationals. In 2021, Mr. Hirtie drove a vehicle without insurance and excess alcohol and was found to be in possession of a knife in a public place. He was given a community sentence, but in 2022, he stabbed another person with intent with a knife and was sentenced to 3 years and 3 months in custody.
That was after 25% discount for plea, wasn't it?
Yes. The Secretary of State wants to deport him, and his deportation is in the public interest. He does not meet the exceptions to deportation in Section 117C of the 2002 Act. The First-tier Tribunal, however, allowed his appeal on the grounds of his family life, and the Upper Tribunal upheld the First-tier Tribunal's decision. And this, as the court knows, is the Secretary of State's appeal from that decision. So I shall seek to persuade you, my lords, that the Upper Tribunal erred in upholding the First-tier Tribunal's decision on two grounds. First, the First-tier Tribunal had erred in law by failing to consider the seriousness of the difficulties that the partner and children are likely to encounter in relocating to Romania with Mr. Hirtie. And second, the First-tier Tribunal's conclusion is legally flawed, inadequately reasoned, and perverse. So subject to any observations, what I propose to do this morning is to address you on law as it applies to both appeals. I will take you to the relevant legislation and key authorities. I will then address you on the facts of Mr. Hirtie's case and will take you to the decisions made below and make submissions on the two grounds of appeal. In doing so, I will also address you on the effect of the fact that the first ground was withdrawn by the Secretary of State before the Upper Tribunal. Law first. Lords, in the authorities bundle behind tab 3, you have section 82 of the 2002 Act. My lords, of course, know that an appeal to the First-tier Tribunal is against the refusal of a human rights claim. That is section 82 1B. On an appeal of this nature, it is the task of the First-tier Tribunal to decide whether the Secretary of State's decision is unlawful under the Human Rights Act as being incompatible with a convention right. At page 29 of the authorities bundle behind tab 3, you will find Part 5A of the 2002 Act, Section page 23. My apologies. Page 23, you have Section 117A of the 2002 Act. My lords will see that subsection 1 provides that this part applies where a tribunal is required to determine whether a decision made under the Immigration Act breaches a person's rights under Article 8 and would be unlawful under Section 6 of the Human Rights Act. Subsection 2 is of central significance to the appeal. My lords will see that it uses the word must. In considering the public interest question, the tribunal must in particular have regard. So there is a duty on the first-tier tribunal to have regard to the listed factors. It depends not on what the Secretary of State has or hasn't said. The duty of the Secretary of State is to have regard, subsection 2b, in cases concerning deportation of foreign criminals, to considerations listed in Section 117C. A failure by the first-tier tribunal to have regard to those considerations would be unlawful as being inconsistent with the statutory duty. The public interest question is defined in subsection 3, and my lords will see that it is the question of justification under the Article 8 analysis under Article 8.2. Section 117C is at page 27 of the bundle.
Can you help me, because it just comes to mind. What happens if you're relying on a different article? Relying on Article 2?
Then this part does not apply at all.
No. So where do you go if you rely on those?
No. So there is no
statutory scheme.
Precisely. So you will simply look at the jurisprudence that relates to Article 2 or Article 3.
Yeah. Yeah.
Well, it's the same thing. When you commit an offence outside the United Kingdom, somebody committed an offence in Italy, and the court said there you really have to go back to the Strasbourg jurisprudence.
Precisely. Yes. So this only concerns Article 8.
Yeah. And I'm not asking questions about must at the moment, although I'm very eager to, because you'll come to it later.
Yes.
You're emphasising must.
Yes.
Must. But you'll need to deal with, I mean, for example, what happens if the parties agree that something is not relevant?
Yeah.
Well, must. So there are a number of stages
Yes.
that will need to be considered as to what must means. Yes, thank you.
So section 117C is at page 27.
But you want to look at 117B first?
Now that provision is at page 25,
Yes.
but it is of no direct relevance to this appeal. So 117B applies to all cases, whereas section 117C applies to...
When you say not relevant to this appeal, you mean to Hirtie?
Yes.
Okay, thank you. Sorry, I was interrupting you again. 117C.
Lord, as you have referred to section 117B, may I just very briefly explain the difference? So if you look at page 26, subsection 6 of section 117B, you will see that that concerns a person who is not liable to deportation. And my Lord will see that a person who hasn't committed a criminal offence, who is not liable to deportation, public interest would not require that person's removal if that person has a genuine and subsisting parental relationship with a qualifying child, and it would not be reasonable to expect the child to leave the UK.
Yeah.
So a different standard applies to those who haven't committed a criminal offence. So section 117C, subsection 1 says that deportation of foreign criminals is in the public interest. It matters not, just bearing in mind the question that my Lord just asked, it matters not what the parties have agreed or decided. Parliament has said that deportation of foreign criminals is in the public interest. If the Secretary of State says in a decision that it's not, or if the parties agree that it's not, then in my respectful submission, that would be of no consequence. The tribunal must proceed on the basis that this is what Parliament has said. The more serious the offence, the greater the public interest in deportation of a criminal is the second principle under subsection 2. Subsection 3, if a person has not been sentenced to a period of imprisonment of 4 years or more, that is this case, the public interest would require that person's deportation unless exceptions 1 and 2 apply. Again, respectfully submit that it matters not for the purposes of this provision as to what the parties have said or decided. Parliament has said that the public interest would require a person's deportation unless the exceptions apply. Exception 1, my Lords will see, is directed to private life. It requires the decision maker to consider whether the person facing deportation has been lawfully resident in the UK for most of his life, whether that person is socially or culturally integrated in the United Kingdom, and whether there would be very significant obstacles to their integration into the country to which it is proposed that they be deported. And this reflects the Strasbourg jurisprudence on the subject. Subsection 5 concerns the family life exception. And that applies where a person has a genuine and subsisting relationship with a qualifying partner, or a genuine and subsisting parental relationship with a qualifying child. And the effect of the deportation of the partner or child would be unduly harsh. So tribunal must decide in a case where reliance is placed on family life, whether there is a qualifying partner or qualifying child, and whether the effect of the deportation on them would be unduly harsh. Now that in turn raises two questions. First, whether the effect of separation would be unduly harsh. This is where the partner or the child would stay in the UK, and the person who has committed the crime would leave. And second, whether the effect of the relocation would be unduly harsh. This is the scenario where the entire family unit relocates on deportation of the person who has committed an offence.
The distinction between stay and go doesn't appear on its face in subsections 4 and 5.
No.
But it is still relevantly in the immigration rules.
Well, yes, it is, but it is in my submission implicit in subsection 5. The case law in subsection 5 tells us that these are the two questions that subsection 5 raises for the decision maker. The effect of deportation would be unduly harsh. Subsection 6, on its face, applies to a person who has been sentenced to at least 4 years. But the courts have said, and the Secretary of State has accepted, that there is a drafting error in the legislation. Subsection 6 also applies to those who have been sentenced to less than 4 years.
who cannot satisfy an exception.
Cannot satisfy an exception, indeed. So subsection 6 says that public interest requires deportation unless there are very compelling circumstances over and above those described in subsection 1 in exceptions 1 and 2. So the phrase over and above those described in exceptions 1 and 2 is central to the second ground of appeal. If you go to page 29 of the bundle, you'll see section 117D. And this is a section that provides a definition of certain phrases. Lords will see that a qualifying child is a child who is a British citizen or has lived in the UK for at least 7 years. And a qualifying partner is a person who is a British citizen or who has indefinite leave to remain, who is settled in the country. It's common ground that there is no qualifying child or qualifying partner in Mr. Hirtie's case. The partner is neither a British citizen nor has indefinite leave to remain. The children are not British citizens and they haven't lived in the country for at least 7 years. So this is the relevant part of the 2002 Act. Just moving on to jurisprudence, there are a catalogue of authorities on section 117C, but what I propose to do is to take you to the lead judgment in the area, Hirtie, Iraq, the Supreme Court's judgment, and then to two authorities of this court as to what Hirtie, Iraq actually says.
Thank you.
And I will seek to explain why, as to how a controversy arose as to one particular observation that was made in Hirtie, Iraq. So if you go to tab 27 of the bundle, you will see the judgment in Hirtie, Iraq. Lords will see that there were 3 appeals before the court.
Sorry, wait a minute, I'm already behind you. Which tab?
Sorry, tab 27.
Thank you.
Page 425.
452.
Sorry, 452. 452. So there are 3 appeals before the court. Those 3 cases were selected for the Supreme Court to consider the tension in the earlier case law relating to section 117C. May I take you respectfully to page 461 of the bundle. At page 461, my lords will see a heading just above paragraph 19, the unduly harsh test.
We just check what the facts are about first, so we know the context and the head note. Just read the head note.
Yes. So, indeed. So 2 of the 3 appellants were medium offenders, whereas the 3rd appellant was a serious offender. So page 461, my lords will see a heading, the unduly harsh test, and under that heading the Supreme Court discusses the earlier authorities and the effect of the judgment of the Supreme Court in KO, Nigeria. The conclusion that is relevant for our purpose appears at paragraph 41, which is at page 466. This is where the Supreme Court explained what the unduly harsh standard actually entails.
Which paragraph?
Paragraph 41.
Thank you.
So my lords will see that the Supreme Court there quoted the MK self-direction. So unduly harsh does not mean uncomfortable, inconvenient, undesirable, or difficult. It poses a considerably more elevated threshold. Harsh in this context means something bleak, something severe. But that would not be sufficient because there is an addition of the adverb unduly. So harsh is an elevated threshold, and the addition of the word unduly raises the already elevated threshold still higher. The court acknowledged that in endorsing that self-direction, the Supreme Court was using language that isn't statutory language. This is paragraph 43. But the Supreme Court took the view that the statutory language caused real difficulties for the courts and tribunals. For that reason, the MK self-direction is endorsed. And if you look at paragraph 44, you will see that the Supreme Court there said that having given that self-direction and recognized that it involves an appropriately elevated standard, it is for the tribunal to make the assessment. So that is the self-direction that a tribunal must give itself. A failure to give that self-direction would be an error of law. It would also be an error of law if the tribunal fails to recognize that this is an elevated standard, elevated by the use of the word harsh, and further elevated by the use of the word unduly.
Can you help me as to what you mean by it would be an error of law if the tribunal did not give that self-direction? What exactly do you mean by that?
In my respective submission, the best approach is to give self-direction in express terms. But I accept that failure to give self-direction in express terms would not amount to an error of law, as long as the judge has, in substance, complied with the self-direction. So in deciding whether a judge has erred in law, the question in substance for the court is whether the judge has directed herself or himself by reference to that standard.
Thank you.
So in other words, the failure to have a paragraph in a decision.
Well, that's why I was seeking to explore with you.
Yeah, good.
You don't have to have a paragraph saying that. Yeah.
But your reasoning in my submission must demonstrate that you have recognized that this is an elevated standard. So this is the unduly harsh test under section 117C5. Just above paragraph 46, my lords will see a heading, the very compelling circumstances test.
Sorry, which paragraph?
Paragraph 46, just above paragraph 46. So in this part of the judgment, the court now deals with section 117C6. And it is paragraph 47 that gave rise, in my respect, submission to some controversy, which was ultimately settled by this court in the two authorities that I'll take you to. So if you look at paragraph 47, you'll see that Lord Hamblen effectively adopts the summary of Lord Justice Underhill in that case. And if you look at subparagraph B, you'll see that it was said that where the exceptions do not apply, a full proportionality assessment is required, a full proportionality assessment. I will explain in due course as to what that phrase means. That phrase was taken by certain tribunals to mean that we are back in the conventional Article 8 assessment territory, where a conventional proportionality assessment is required. But the court has now clarified that that isn't the case, and I'll take you to do judgments. Paragraph 49, Lords will see that the judgment in Hashim Ali.
Before you leave paragraph 47,
yes.
in 2047B makes it quite clear when it talks using the label of full proportionality requirement. It says in conducting that assessment, the decision maker is required to proceed on the basis that it's in the public interest unless it's over and above 1 and 2. It's not a freestanding proportionality assessment outside the statutory provisions.
Absolutely.
It's on the basis of the statutory provisions.
Yeah. My Lord is absolutely right. And this, in effect, is what this court has said in two subsequent authorities. So paragraph 49, my Lords will see that a passage from Hashim Ali is quoted. And my Lords will see that that court says that great weight should generally be given to the public interest in deportation. Great weight is the phrase that I respectfully emphasize. Now there was a reason why the word great is used.
Yes.
There is a public interest in deportation of every foreign criminal. But where exceptions do not apply, or someone is a serious offender, then there is a greater public interest in that person's deportation.
Wasn't Hashim Ali decided before the 2014, or in respect to the laws that applied before the 2014 amendments?
Absolutely.
And didn't they suggest that the way to deal with it was to make legislative amendments? And so we're now dealing with the legislation, not with the position as it obtained before those amendments.
Lord is absolutely right. So what the Supreme Court said in Hirtie, Iraq, is that in making the assessment under Section 117C6, the approach to adopt on the question of public interest is one that was set out in Hashim Ali. So true it is that Hashim Ali was decided prior to the amendments to the 2002 Act, but the statement of principle that great weight should be given to the public interest in deportation of qualifying offenders.
I thought great weight was reflected in the provisions of 117. We're looking at subsection 6, that the public interest requires deportation unless. Isn't that how great weight is given to the public interest? We'll come to the later authorities. Thank you.
Thank you. So that is paragraph 49.
Yes.
Perhaps just to yes, bearing in mind the question, if you go to paragraph 51,
Yes.
you will see that Lord Hamblen says that when considering whether there are very compelling circumstances over and above the exceptions, all relevant circumstances will be considered and weighed against very strong public interest.
Yes.
So, my Lord, we'll see the use of word very in that.
I know. I'm not disagreeing with that. I'm saying that that is what Section 117C6 says in terms that you're giving very strong public interest. Sorry, very great weight to the public interest because the public interest requires deportation unless there are very compelling circumstances. But anyway, sorry, I'm repeating myself. I'll be quiet.
Yeah.
Oh, no, don't.
My Lord, Section 117C1 says that deportation of foreign criminals is in the public interest.
Yes. I know.
Deportation of every foreign criminal is in the public interest. This is what the statute says.
Yes.
What the Supreme Court is saying here is that when it comes to deportation of serious offenders or offenders in relation to which the exceptions do not apply, there would be an even greater public interest, great public interest, or very, very strong public interest.
Because it takes more to overturn it or to overbear it. The interest is greater, partly because the section says so.
Yes.
The more serious the crime, the greater the public interest.
Yes.
But on what you've just said, there are two categories for whom there have to be very compelling circumstances. One is people sentenced to less than 4 years who can't meet an exception 1 or 2, and the other is people sentenced to more than 4 years.
Yes.
Have I understood that correctly?
That is correct, yes.
Good.
In terms of public interest, you've actually got to go back to the 2007 Act, which says 1, deportation is conducive to the public good, and 2, imposes a duty on the Secretary of State to deport because Parliament thinks it's important. And then it says there is an exception, and the exception reminds us of the public interest in deporting foreign criminals. So you've got to see the whole context.
Yes.
What Parliament's been trying to do.
Indeed. So no difficulty with that. The simple proposition that I'm seeking to put forward is that there's a difference between a medium offender and a serious offender.
Yes.
That really is.
All I'm saying is that, as I read it, the effect of the legislation, as my Lord said, read as a whole, is that there is a very strong public interest in the deportation of serious criminals, and I think that's what you're submitting.
Yes.
Yes. Thank you.
So, when considering whether there are very compelling circumstances over and above the exceptions, all relevant circumstances of the case will be considered. All relevant circumstances. And weighed against the very strong public interest. You then have reference to Strasbourg case law and a summary of factors that are considered to be relevant. The Strasbourg case law summarized the relevant factors. These are relevant factors. The nature and seriousness of the offence committed by an applicant. The more serious the offence, the greater is the public interest.
Again, you've got to remember the opening words of 51. They're not saying start again and look at all these factors.
Yes.
They're saying when you're deciding whether something goes above 1 and 2,
Yes.
these are factors to look at to see if they go above 1 or 2.
1 and 2.
Not look at these factors full stop.
Absolutely, absolutely. This is in effect what this court has said in two authorities that I'll take you to. Now this list, in my respective submission, is helpful. It comes from Strasbourg case law. My Lord will see that one of the matters that the fact finder would consider is the length of the person's stay from the country to which he or she is expelled, the time of the offence, nationality of various person concerned, so whether a child is a British citizen, a partner is a Romanian national, that is relevant. The length of the family situation, the length of marriage, the age of the child. And then sixth or seventh bullet point, the seriousness of difficulties which the spouse is likely to encounter in the country to which the applicant is to be expelled, the welfare of the children, and the seriousness of the difficulties which any children of the applicant are likely to encounter in the country to which the applicant is to be expelled.
And the wider context for this is that this is all speaking in the context of a challenge to a decision by the Secretary of State.
Right, yes. Yes. Indeed.
So, but that is, I'm sure you'll develop this as we go through, but that strikes me as being quite important, that this is not a freestanding, this is what a first-tier tribunal's got to do. Because what a first-tier tribunal's got to do is decide whether the Secretary of State's, the challenge to the Secretary of State's decision is to be upheld.
Yes.
And that's the context.
Yes, so the first-tier tribunal makes its own assessment of proportionality. The first-tier tribunal decides for itself as to whether the interference with the Article 8 right is proportionate.
But if something's not an issue, if something's not raised by the Secretary of State's decision, I'm sure you will come to this, but I am particularly interested to know how the first-tier tribunal is meant to deal with that.
In my respective submission, it matters not. So take an example of a case where there is a child in the family and the Secretary of State says nothing about the child in the decision. That does not mean that on appeal the tribunal will say nothing about the welfare of the child or would simply assume that the child's welfare requires the person to stay with the child in the UK. My submission is that the obligation on the tribunal is to assess the Article 8 claim by reference to the criteria in Section 117C, which in turn places an obligation on the tribunal to consider whether the effect of the deportation would be unduly harsh on the child or the partner.
Yes, but that's because it's in Section 117C.
It is, yes, that is because it is in Section 117C,
Right.
and also, and my submission also because it is in the Strasbourg jurisprudence.
It is your submission that a tribunal in every case has to consider every one of these, but no others? What happens if there's another factor that happens to be relevant? So you're saying a tribunal in every case must set all these out and consider them expressly in its decision. Is that your submission?
My submission is that the tribunal must, in every case, consider the criteria in Section 117C.
That's different.
So, yeah, so that is...
Does that mean your answer to my Lord's question is no?
Yeah, the answer is yes. But my starting point is that that in making the assessment of the Article 8 claim, the decision maker must consider Section 117C, must consider the two exceptions in the question of very compelling circumstances. And that includes consideration of whether the effect of deportation would be unduly harsh. I also submit that when one reaches the Section 117C6 stage, these are the relevant factors that in Article 8 appeal a tribunal must consider. But
You
this
think
is,
about that. You must consider in the context of exceptions by 1 and 2. And the second thing, you haven't looked at paragraph 52, which recognises that you can have legislation on a number of the factors referred to. The weight has now been answered by the legislation. How much has it got to affect the child? Answer's got to be unduly harsh, and all sorts of things. So you don't just do that. Many of them will be answered by applying exceptions 1 and 2. So we need to be careful about saying Parliament has structured it to do exercise of working through all of these. You've got to go from the beginning to the end.
Lord, I respectfully agree. So, for example, this list requires consideration of whether the seriousness of difficulties that a spouse or a child is likely to encounter, that is in substance section 117C5 question, whether the seriousness of the difficulties are such that it would be unduly harsh to expect the family to relocate.
I'm sorry, I'm not following this. Is it your case that in every challenge such as Hirtie, the tribunal has to list and address every single one of the bullet points in paragraph 51?
Yes.
It is.
Okay.
Okay.
If there are, but this isn't an exhaustive list. Of course, if there are other factors, then the fact finder will consider those factors.
Sorry, that seems to be placing the decision or those factors over and above the legislation.
In my submission, that is not the effect of the submission that I'm seeking to make. So many of these factors. So when a judge reaches section 117C6 stage, the judge would have already considered many of these factors in the assessment of exception 1 and exception 2. For example, in assessment of exception 1, the first-tier tribunal judge would have already considered the length of time the person has been in the country and the length of time that he has been absent from the country of deportation.
Well, they'll have looked at the solidity of social, cultural and family ties, because it's very significant obstacles. Most of these have now been translated into the legislation. It's possible that some of them haven't, and they don't expressly say what's he been doing since he was last convicted in the legislation. But most of these now will already have been included in the legislation, as they can do, see paragraph 52.
Yes. So, Lord, when I say that in a case of this sort, a judge must consider all these factors, I submit that, see it on the basis that in making the assessment of under section 117C6, a judge would already have considered many of these factors in the assessment under section 117C4 and C5.
But you've accepted that the context is a challenge to a Secretary of State's decision. If one of these factors plays no part in the Secretary of State's decision, why does it have to be brought back into account by the First-tier Tribunal? I don't get it.
Yes, in my respective submission for three separate reasons. First, because the First-tier Tribunal is not exercising a review function. The First-tier Tribunal effectively is the primary decision maker. The First-tier Tribunal decides for itself whether deportation would breach Article 8. Second, because Parliament has said, by enacting subsection 4 and subsection 5, that these are the matters that the First-tier Tribunal must consider. And third, because the Strasbourg case law says that these matters must be considered in a case of this sort.
Must.
Yes.
Does it say must?
Yes.
In every case, all of these factors must be considered. Surely the Strasbourg case law says these are relevant, likely to be,
So,
maybe, will be, can be relevant factors.
so in case of this nature, in case like Mr. Hirtie's case, the language that is used by Strasbourg jurisprudence, replicated at paragraph 15, is that all relevant circumstances of the case will be considered, and the Strasbourg case law and the relevant factors will include those identified by the Strasbourg Code as being relevant to the Article 8 proportionality assessment. So these, in my submission, the Supreme Court has said are relevant factors that should be considered in my respective submission in every case of this nature.
So the parties come to court, nobody has raised relocation as an issue, no evidence has been given, come to the tribunal, no evidence has been given about relocation. You say the tribunal will have to adjourn the case, say you need to address this evidentially, even if the parties say nobody's raising it, we don't want you to consider it, it's not an issue that requires being dealt with. You say they have to adjourn it, they have to ask for evidence, they have to deal with it, in every case.
I say that in every case they have to consider this.
Even if the parties haven't given evidence about it?
Yes. So
how does that lead to a fair determination?
yes. So if for example, both sides agree before the tribunal that relocation would be unduly harsh, the judge must consider that as part of his or her evaluation. But a judge can simply
that's
say...
a different point. If it's not raised as an issue. You're saying the tribunal is a forensic ferret that has to identify this issue. And I think you're saying because the tribunal is required to do so by the legislation.
Yes.
Even if the parties haven't. So that if the parties come to the tribunal and it hasn't been raised, the tribunal judge is required to adjourn the case to give them an opportunity to give evidence about that issue.
Lord, the submission, in short, yes.
That's procedurally coherent, sensible way to conduct tribunal proceedings.
Lord, if you look at the matter in the proper context, which is that Parliament has legislated on the subject, Secretary of State has made immigration rules reflecting the statutory framework, an applicant knows, or is expected to know, that public interest would require his deportation unless, in a case of medium offender, the effect of the deportation on the child or partner would be unduly harsh. So they know that this is the case that they have to put forward.
That isn't this case because nobody can rely on the exceptions. And the issue is whether there are exceptions, very compelling circumstances over and above exceptions 1 and 2. And the Secretary of State says yes. It says no, because there won't be a problem with separating the child. And the First-tier Tribunal said, no, we disagree with you on that. There will be a problem if you separate the father from the child. Therefore, you can't justify deportation on those grounds. That would be a breach. And the Secretary of State didn't take any position about whether or not allowing them to remain rather than removing would be a breach. It clearly wouldn't be a breach of Article 8 to let them remain. May not be what Parliament would have liked, but the Secretary of State hasn't said it is a breach.
Lord, I will address you on the facts. I'll take you to the decisions made below. I will seek to submit that there was no concession by the Secretary of State. Indeed, the Secretary of State said that these exceptions are not met.
So if the criminal has a child or children,
yes,
doesn't raise that it would be unduly harsh on his or her children if he was deported, there's an obligation on the tribunal to say, hold on, I need to consider this issue.
Yes.
I need evidence. You're going to have to adjourn, even though you haven't raised it, you don't want to raise it, I have to consider it.
Yes.
So there has to be evidence as to whether it would be unduly harsh.
Yes.
Again, is that a coherent, sensible way of conducting
Well,
proceedings before the tribunal?
Yes, my lords, I'm sure have picked a case called Robinson in the authorities bundler in the skeleton. So the duty on the tribunal is to make a decision that is compatible with the convention rights. So
Yes, but if nobody raises it, if nobody says it would be unduly harsh on my child or children, it's that the tribunal still has to investigate whether it would be.
Yeah, so the tribunal has to make a decision as to whether the effect of deportation would be unduly harsh. If both sides agree that relocation would be unduly harsh.
No, you keep putting that in. That's not the point I'm making. I'm saying it hasn't been raised. I think if a tribunal raised at a hearing, I want to see whether it would be unduly harsh, it would be a surprising party who said, no, don't worry. They would like to go out and get evidence to address that issue. I'm just looking at the effect of what you're saying. It's in every case the tribunal, in a sense, has to act as an investigative tribunal. You'll come on to LATA and the rules in a moment, because they would seem rather contrary to the submissions you're making. But I'm just looking at it from a practical effect.
Yes.
Because this would have to apply both to the points that might favour the Secretary of State and points that might favour the criminal.
I recognise that, of course. Now, if there is a child in the family and the child is a British citizen and deportation will have an effect on the child, the tribunal, in my submission, is obliged to consider whether or not the applicant has said anything about the effect of the deportation. The tribunal has to decide for itself whether the effect of the deportation would be unduly harsh. If the tribunal goes down to the path of not engaging with the matter at all, on the basis that the parties have not raised it, that could give rise to an error of law. Robinson is the authority on the point from the perspective of an applicant. If there is a convention, if there is an obvious convention point in favor of an applicant, which the applicant hasn't raised, there can be an obligation on the judge to deal with it.
The task of the tribunal is to determine an appeal under Section 82, that there's been a decision and there's an appeal. And in deciding that, they've got to have regard to certain considerations, but they're considerations relevant to determining the appeal rather than a freestanding, the tribunal is there as a safeguard or guardian of the public interest. And no matter what the parties say, no matter what the scope of the appeal is, they must always check whether letting somebody stay here, if they're a criminal, is a breach of Article 8.
Yes.
You would like to have, by the sounds of it.
Yes, my submission is that is the effect of the legislation. The legislation says that in considering the public interest question, the tribunal must have regard to considerations in Section 117C.
But why are paragraphs 51 and 52 not a complete answer to that bald assertion? Because 51 says relevant, got to be relevant, and 52 says the weight to be attributed is for the tribunal. If the tribunal is confronted by a decision which is being challenged, which takes no point on it, I'm just leaving it neutral for the moment, takes no point on an issue, relocation, and the neither party before the First-tier Tribunal raises the point at all, why isn't the proper assumption that this does not form part of the original decision, and there is no basis for making it form part of the challenge to the decision, and you do that by saying, no, wait. What's the problem with that?
So you consider a matter and you then decide to attach.
So you don't have to consider the matter because no one's raised it. Or it's not in issue. Or I prefer the phrase, it's not in issue. Something's got to make it in issue. As soon as it's in issue, I can follow the rest of your submissions. But we're dealing with a case where the case against you is that it's just not in issue. I know what you say about concessions and not concessions and so on. We'll come to that later. But assume it's in normal legal parlance, it's just not in issue. Isn't the answer that whether it's addressed expressly in the First-tier Tribunal's decision or not, it is to be taken as having no weight afforded to it?
In my submission, no. The submission is that would be inconsistent with the statutory language. Parliament has decided what will be an issue in an appeal of this sort. And those are the issues that the tribunal must grapple with, no matter what the Secretary of State has said. Now, may I take you to an authority that may persuade you, my Lord, to take a different view?
Yes. Where are we going?
That is tab 37 of the bundle. The judgment of this court in Burgess. Now, this is a deportation appeal, but an appeal that was decided by reference to the regulations and the directive. If you go to...
well, hang on, can I just read the head note to see what it was about? I remember an EU citizen, and the director said could only be deported on imperative grounds of public security.
Yes.
No such grounds have been shown to exist.
And the Secretary of State, my Lord, raised no imperative grounds in her decision.
And the Secretary of State said he didn't enjoy that level of protection because he hadn't been in the UK for 10 years.
Yes.
So is it all about what 10 years means?
That was the first point in the appeal.
So the first point was essentially an issue of, jurisdiction in a sense, as to whether or not the person had achieved was entitled to the highest level of protection.
Yes. May I then may I show you the paragraphs that are relevant to the argument? So if you go to paragraph 43 of the judgment.
I think it is quite important to understand what the case and issues are about, rather than just taking sentences completely.
No, I was going to explain.
And looking at 3, for example, there are 2 issues in this appeal. The first is the correct construction, which seems to be the 10-year point. And that seems to be about whether you had to be a citizen during the whole period. And then the second issue is, did they err in the test to removal?
So, my Lord, I will, of course, not simply pick sentences, but may I just show you a couple of paragraphs to explain what the issue was and how the court decided that issue. So, if you go to paragraph 43 first, page 673.
Thank you.
You'll see that the court referred to regulation 27.
Did you say paragraph 23?
Sorry, paragraph 43, my Lord, at page 673, paragraph 43.
Paragraphs 2 to 6 are headed application.
My apologies, my Lord. It's paragraph 43, which appears at page 673.
Regulation 27.1.
Yes.
Thank you.
So This was the equivalent in the regulations to what the immigration rules and the statute says about deportation of foreign criminals who were not citizens of EU. So Regulation 27 defines the relevant decision, and 27.3 says that a deportation decision must not be taken in relation to a person with a permanent right of residence except on serious grounds of public policy and public security. And then, bearing that in mind, if you look at paragraph 44, Regulation 27.5 explains what the public policy and public security requirements of the United Kingdom include and what principles govern such a relevant decision. 27.6, which in my submission is equivalent to section 117A. This is on page 674. Regulation 27.6 requires the Secretary of State to take into account various considerations before taking a decision. And this mirrors the directive. And if you look at the language that appears, Regulation 27.8 requires a court or tribunal, the same language that is used in the statute, considering whether the requirements of these regulations are met, in particular to have regard to considerations listed in Schedule 1. So the legislation there said that a tribunal is required to have regard to considerations listed in Schedule 1. So those are the sort of public interest considerations equivalent to section 117C. Now, in that case, the Secretary of State had not said anything about those considerations and the relevant standard in her decision. And the tribunal ruled in favor of the appellant, held that the deportation was not consistent with the regulations, and the tribunal allowed the appeal.
But for the purpose of this case, we need to know much more, because
yes.
we need to know whether it was, the issue was, what does 10 years count? Does it depend on when he became a new national? Does it depend on whether he was in prison? Then we need to know what the Secretary of State had decided, and then we need to know whether it was part of the argument that the issue was wrong about misdirection. She had to take the issues. You can't just say, look at the regulations, the similar words, and look at the decision.
No. So
I will. More complicated than that.
No, of course. So I will, of course, take you to the paragraphs where submissions are made and what the court has said. It's just simply showing you at this stage what the regulations said, and simply pointing out the similarity in the language that is used in the regulations. Now, if you then go to paragraph 109. Yes, 109 of the judgment.
Yes.
So, page 687. On the second ground, you'll see that the submission that Mr. Burgess made was that the tribunal's approach should be endorsed. The court should be reluctant to interfere with the assessment of the specialist tribunal. Paragraphs 3 and 7 do not apply to imperative grounds of public security, and the Secretary of State had not in any event put forward any such grounds. And the first-tier tribunal was entitled to find that there were none. So neither in the decision made by the Secretary of State nor at the hearing, the Secretary of State sought to put forward imperative grounds of public security by reference to Schedule 1. And the First-tier Tribunal, in a sentence, said that there are no such imperative grounds.
Sorry, there are no.
There are no such imperative grounds justifying deportation, because no such grounds were identified by the Secretary of State either in a decision or at the hearing.
She was saying, I don't have to deal with that because this isn't a case where the 10 years are met and imperative
Yes.
grounds apply. She was saying, therefore, it's a lower test.
Yes.
And the first question was,
Yes.
was she wrong about that? And the answer was, she was wrong about that.
Yes. That was the first question. The second question was whether the tribunal erred in law in holding that there were no imperative grounds justifying deportation. The Secretary of State's argument was that there is a duty on the tribunal, because of the language that is used in Regulation 27, to have regard to the relevant factors in the legislation and to decide whether there are or there aren't imperative grounds justifying deportation. Mr. Burgess, on the other hand, submitted that, well, if the Secretary of State felt that there were imperative grounds, she should have said so in her decision or at the hearing. The fact that the decision was silent, the presenting officer was silent, meant that the tribunal made no error in allowing the appeal, in holding that there were no imperative grounds. If you then go to page 690, you will see a heading, Ground 2. And this is where the discussion as to that ground starts. So the first question on Ground 2 is whether the tribunal erred in its approach to the imperative grounds of public security. The starting point is not the Secretary of State's decision. The starting point, the court said, is the scheme and the directive, the scheme of the directive and the regulations. The appellant's submission was rejected, and my lords will see that the court said against letter B that the First-tier Tribunal was bound by Regulation 27.8 to take into account, in particular, considerations in Schedule 1. And it was bound to do so whichever of the two tests it was applying. The fact that the decision did not refer to the second test is not because the Secretary of State conceded that the second test was not met, but because the Secretary of State did not consider it was relevant. The First-tier Tribunal, having decided that the second test applied, was obliged by Regulation 27.8 to consider for itself, though it wasn't raised by the Secretary of State or the presenting officer, whether the test was met, having regard in particular to the considerations in Schedule 1, and to give reasons for that decision. It did not do so, it erred in law. So,
I'm sorry, I just don't see that applies by analogy. The decision didn't refer to the second test because the Secretary of State did not consider that it was relevant.
yes.
And the Schedule 1 sets out a long list of matters, one of which is the fundamental interests of society. And the fundamental interests of society include a number of factors.
Yes.
And I don't read this as saying that in every case, the tribunal has to consider every one of those factors. So I'm not speaking for myself, sure that a different legislative structure with different wording, different phrasing, can be applied to our legislative structure. We have to decide. Your submission is that must,
Yes.
in the context of very compelling circumstances, when exceptions 1 and 2 don't apply, includes, in every case, a requirement, whether it's raised or not as an issue, for the tribunal to consider relocation.
In a case of this sort, yes, where there is a partner and a child.
Could you turn that off?
Yes, and I
Thank
say,
you.
Yes, and Lord, you have my submission. I say that you get that from Section 107C from jurisprudence, this authority in my submission applies by analogy the proposition that paragraph 119 endorses.
But this seems to be the other way around in this case. The chap seems to be saying, look, you can't deport me because there aren't imperative grounds. And the Secretary of State says, aha, I don't need to prove that. I only need to prove something less than.
Yes.
The Secretary of State was wrong. She should have considered imperative grounds. And she knew that if she was wrong, she'd have to do that. So somebody has then got to consider the imperative grounds, because if they sent him back without considering the imperative grounds, there might have been another of law. But here it's different. The Secretary of State isn't proposing to send them back on one reading of the letters. She's saying, oh, it's all right if they stay here. And the question is whether sending him back, leaving the family here, would result in Article 8 problems. And the Secretary of State said, no, it wouldn't. And the tribunal said, yes, it would. So why do they have to switch, is the question, to a different factual scenario, which isn't the automatic consequence of a misdirection on the law?
Lord, in that case, as 119 provides, the Secretary of State did not deal with the imperative grounds, not because she considered that there were no imperative grounds. She took the view that there was no need for her to...
She considered it wasn't relevant to apply that test, so her mind was blank on that.
Yeah, so, and she was wrong.
Yeah.
But the fact that she did not consider that in her decision did not lead to the conclusion that the first-tier tribunal can simply ignore that completely, or simply say in one sentence, as this tribunal did, that there are no imperative grounds. The first-tier tribunal was obliged by the legislation to have regard to the listed considerations and to give reasons as to why the tribunal was deciding that there are imperative grounds, despite the fact that it wasn't said in...
I mean, all this decision, that, to my mind, decides is once the First-tier Tribunal had decided the second test applied, it had to apply the second test, which is hardly rocket science.
Yes, despite the fact that the Secretary of State had said nothing.
Well, because the Secretary of State said the second test doesn't apply. So there was an argument about what test applied. But once the correct test had been identified, it had to be applied. Is that what this case decides?
Yes.
So
I didn't mean to be pejorative to it by saying it's
So,
not rocket science, and I apologise to the court in that case.
For starters, for it to be of assistance in our case, you would have to persuade us that the absence of any mention of relocation in the Secretary of State's decision is because it's not relevant.
No.
It very often, forgive me for not knowing the answer to this, but very often in these sort of cases, the Secretary of State says to the applicant, there's a one-stop shop, you've got one opportunity to tell us the answer. I've just looked at the decision letter here, I don't think you do it here. Is there an obligation on the Secretary of State to enunciate the reasons on which she relies in the decision letter?
There is an obligation to give reasons for the decision.
To articulate the reasons why she takes the decision.
Yes.
Fine.
Yes.
So
Where does that come from?
It's
It's just a public law.
Yes.
Yeah.
Yes.
You have to give reasons for your decision.
Yes.
Well, the notice regulation said you had to, but I haven't gone back and read them.
Yes.
The public law will require decisions,
Yes.
the reasons to be given.
But when one reaches the appeal stage, then the appeal tribunal becomes the primary decision maker.
No, it's hearing an appeal. It's not the primary decision maker. It's never the primary decision maker, but it will decide whether Article 8 would be breached if the decision is given effect. It's not right to say they stand in the shoes of the Secretary of State.
Well, Lord, this court has said that it does, and this court has said that the tribunal is
It's got to take a decision for itself on proportionality, actually, but you need to be careful about it.
Yes.
It's got other, don't get into that today,
Yes.
it's not relevant. But the problem here is, he appeals to the Secretary of State issues a deportation notice. He's entitled to make a human rights claim to the Secretary of State and say, look, if you do this, it will breach Article 8. The Secretary of State then has to decide whether it will breach Article 8, and if not, why not? And all she seems to have said in this decision is, it won't breach Article 8 because the effect of separation isn't too harsh, and the tribunal disagrees with that. She didn't go on to say, and in any event, it's quite reasonable, given your limited leave to remain here, to relocate.
Yes.
And she stopped short of saying either of two ways would be satisfactory with Article 8. She proceeded on the basis that they would stay here, but separation wouldn't be wrong. If that's not correct, then she's not put forward any argument that Article 8 would be breached by deporting him and everybody else as well.
She hasn't, of course, and there is that gap in the Secretary of State's decision. Hence we are here.
Okay.
And I'm making the argument that there is.
So
may I just make one sort of concluding submission as to Burgess, paragraph 119, and then I'll move on to the other point.
yes.
A question that is put to me is that the Secretary of State has made a decision, and this is an appeal from that decision. One matter to consider is what is the starting point? Is it that decision that is the starting point? Or the starting point is something different? The submission that I make is that in an appeal, in a deportation appeal of this sort, the starting point is the legislation, the law, as opposed to the Secretary of State's decision. And paragraph 119 of Burgess supports that proposition that the starting point is the legislation in deportation appeals under the regulations. The second submission is that the fact that the Secretary of State did not consider a matter that legislation says is relevant does not mean that the tribunal proceeds on the basis that it's not relevant.
That's the point of my last question to you.
Yes.
Because we will come to it, well, since you've made the submission now, if there is an obligation on the Secretary of State to articulate the reasons for her decision,
Yes.
seems to me at the moment that there's no basis for an assumption that a failure to mention something is because she doesn't think it's relevant. It may simply think that she doesn't think it's a matter that should be given any weight, which is different.
Yeah.
So what is it about the decision in our case which entitles you to say, or justifies you in saying, that the silence is because it's not relevant and therefore akin to Borges? Because at the moment I can't see it.
Yeah. Lord, may I address you on that when I conclude my submissions on law and take you to that?
I'm quite happy to wait.
Yes.
Thank you. Yes, we're now.
So this is Borges. So may I then take you to two authorities on my second ground? I can see.
Are you going to deal with LATA and the way in which the tribunals now require or expect parties to conduct themselves in the course of proceedings before it?
So the short point here is that the guidance in LATA wasn't followed. So the procedure under LATA and the revised procedure is that an appellant would file a skeleton argument and evidence. The Secretary of State will then conduct a review of that skeleton and evidence, identifying the relevant issues. There was no review in this case.
And that's why I'm saying it's wrong to talk about primary decision making, merging two concepts. The tribunal is hearing an appeal against a decision. And 117 says what it takes into account when deciding that appeal. There are also provisions governing how the appeal is going to be conducted.
Yes.
And if that is meant to construct a clear set of issues for the tribunal, and the Secretary of State hasn't put it in the decision letter, and she hasn't used the procedural rules. The question then is, why is that an issue within the appeal that the tribunal must turn to? Because they are dealing with an appeal. They're not deciding whether to deport or not. They're deciding whether the decision to deport should be allowed on appeal.
Yes. See, completely understand the point, and the submission remains that it is the Parliament who has decided what is an issue in appeal of this sort. So it is an issue, no matter what the Secretary of State has said, in a case of this sort, whether the effect of deportation would be unduly harsh. If the Secretary of State concedes in her decision that relocation would be unduly harsh, or if the presenting officer says to the tribunal that I concede on the evidence that relocation would be unduly harsh, the tribunal can entirely legitimately say that, well, I also find that relocation would be unduly harsh, and make a decision accordingly.
So your submission, as I hear it, is that when looking at exception 2, there is an obligation on the tribunal to consider every potential factor relevant to whether deportation would be unduly harsh, whether or not raised either by the Secretary of State or by the applicant.
No, my Lord. The submission is that the tribunal must consider whether the effect of the deportation would be unduly harsh, and that
Yes.
and that in turn requires the tribunal to consider the two questions.
Why only relocation? Why not any other factor relevant to the issue of whether the effect of deportation would be unduly harsh? Why only relocation? There could be any number of factors that might be relevant that haven't been raised by either the Secretary of State.
Yes,
So any factor relevant to that issue, even if not raised by the Secretary of State or the applicant, has to be considered by the tribunal.
now in my submission, not every matter, but the question of whether separation would be unduly harsh, the question of whether relocation would be unduly harsh.
Why is it confined only to relocation? That's what I'm asking you.
Yes, because the statute confines it to the effect being unduly harsh.
Yes, but it's the effect of deportation.
Yes.
So there could be any number of factors, as we can see from the range of authorities and decisions, any number of factors that are relevant to that issue, one of which could be relocation. But there's only one potentially relevant factor. So why does your submission not apply to all potentially relevant factors to the question of whether the effect of deportation would be unduly harsh, would or would not be unduly harsh?
Lord, I'm not sure if an example immediately comes to mind as to what other factors my Lord feels are relevant to that question. Is it welfare of a child, for instance?
Well, it could be whether the child has mental health issues.
So that is yes. So that
And you're saying even if not raised by the parties, there would be an obligation, because it's potentially relevant, for the tribunal to investigate that factor.
no, of course that isn't my
Because
position.
you see, if you look at Borges, Borges is talking about a high level of consideration. You've got to consider the specific elements identified in Schedule 1. What the tribunal has to consider is whether the effect of deportation could be unduly harsh or would be unduly harsh or might be a result. There can be a whole range of factors that might feed into that issue. Are you saying that Parliament, I mean, with greatest respect, I really don't see how Parliament has stipulated what factors the court must consider whether determining whether the effect of deportation would be unduly harsh. The tribunal has to answer that question.
Yes.
But there's nothing that says in the legislation what factors the court has to consider.
Yeah, yes. I accept that. The submission is that the obligation is to consider that question, whether the effect would be unduly harsh. And that question, in turn, give rise to two questions, whether separation would be unduly harsh or relocation would be unduly harsh. And the submission that I make is that there is an obligation on the tribunal to consider those two questions.
Did I note this down right? You started as about 4 minutes ago, you said if the Secretary of State concedes that relocation
Yes.
would be unduly harsh, I think, it remains a question for the tribunal to decide whether the effect of deportation would be unduly harsh.
Yes,
Have I got that right?
yes.
But if the effect, we can argue about concession or discuss concession later, but if the effect is that the Secretary of State would not contend that relocation is not unduly harsh, if that's the state of play for the tribunal, can't it just, why doesn't it just, it parks relocation because it's been accepted that that would be unduly, the effect would be unduly harsh, and then you go on, as this decision did, to look at the alternatives, namely stay, and make a decision as to whether that's unduly harsh. Whichever way you do it, whether you come at it through LATA or if you come at it through paragraphs 50 and 51 of whatever it is, you get to the same position, don't you? Which is, if it's not an issue, it's either given no weight, or it's not taken into account, or it's, if I just put it, parked, because it's not going to affect the outcome. That's what troubles me, particularly in a situation where the Secretary of State has an obligation to articulate grounds of objection or rejection.
Exactly, yeah. See the point. I'm not. You have my submissions.
Okay.
What is an issue?
Okay.
Is what Parliament has said is an issue. And if the Secretary of State makes a concession, accepts that relocation would be unduly harsh, the tribunal acknowledges the concession, accepts that relocation would be unduly harsh, and make a decision. If the Secretary of State says nothing about that matter, the tribunal says that the Secretary of State has said nothing about it, I'm satisfied that relocation would be unduly harsh, and makes a decision that would be unobjectionable. The objectionable course would be where the tribunal says absolutely nothing about it. In other words, where the tribunal fails to consider the question. On LATA, I said that procedure wasn't followed.
I know, but that, with respect, is not an answer, because what you're seeking from us is general propositions, and if we were to enunciate general propositions, we would need to take into account the procedural structure to see whether it fits, whether your submissions fit within that structure.
Yeah.
Yes. When properly applied.
Yes. Can I then perhaps take you to LATA then? Yes, page, so it's tab 28, page 486.
Yes.
If you go to page 491, my lords will see a heading. and sort of general guidance as to the new procedure is at paragraphs 20 to 22.
Again, it's quite helpful. Do you mind if I just look at what the issue was?
Yes.
And that's in paragraph 4. This case raises the question whether it's open to a party to proceedings in UTR. So can an Upper Tribunal take account of an issue which is in the absence of a controversial issues below? And the issue was what? That
I mean, this wasn't a deportation appeal and asylum appeal, so
Does that matter?
it does, because there is no provision similar to section 117A and C that applies in asylum cases. In asylum cases, the burden of proof is on the appellant. So this is in a different context. But of course, the practical effect of the guidance is that where it is complied, the situation like this is unlikely to arise. So where a decision of the Secretary of State is silent on a matter that is obviously relevant because of an error or omission, if a skeleton argument is filed identifying the issues, then in all likelihood, if there is a review, the reviewer will pick that and make it clear that that is an issue.
Is it your submission that latter doesn't apply to this case?
The submission is that the analysis in LATA does not defeat the argument that I'm seeking to make. The guidance that is given in LATA applies to all appeals. I accept that there should have been a review in this case. There should have been a paragraph in the decision letter. I completely accept that, saying that, well, relocation would not be unduly harsh. The fact that there isn't a review or the decision is silent, the submission is that does not mean that the First-tier Tribunal makes no error of law if it fails to address the question that Parliament has said is relevant. I mean, take example of a case where the decision does not say that deportation of foreign criminals is in the public interest. The Secretary of State is silent about it. Now, on appeal, can the tribunal assume that, well, the Secretary of State hasn't said that deportation of foreign criminals is in the public interest? I am going to proceed on that basis. That deportation of foreign criminals is not in the public interest. No would be the obvious answer, because Section 117C says that it is in the public interest.
Section 32 says it's in the public interest. Parliament has already decided that. That isn't an issue, because there is one answer. It is.
Precisely.
And if the Secretary of State of the Tribunal said, no, it's not, that would be an error of law, because it would be a breach of a decision by Parliament.
So why I respectfully invite my lords to consider that is different from Section 117 C4 and C5. Parliament has decided that deportation is in the public interest unless the exceptions apply. If the Secretary of State has said nothing about an exception, and the tribunal allows an appeal without making a finding that an exception applies, that would be inconsistent with the statute and would give rise to an error of law.
But if the Secretary is accepted and exception applies, then she's accepted that there's going to be no deportation. Well, this is an appeal. It's not a decision exercising immigration powers. It's an appeal under Section 82, and there are procedures governing an appeal. The question for the tribunal is whether or not deportation, whether deportation would breach Article 8. And the thing we keep coming back to is, if something isn't said to be an answer to that, why should they investigate it? On that analysis, they should have investigated all sorts of other things as well. And does 117A really mean must have regard to considerations, mean just don't forget to look at what's listed there, or every one of them must be treated as relevant and be assessed? Look at the considerations in 117C, brackets, obviously, where relevant, close brackets, and they'll be relevant when they're raised, and unlikely to be relevant when they're not. But you say, no, that's not what 117A means.
That is the submission that I do make. So may I then, of course, recognizing what the court has said, take you to two authorities on ground 2.
Right. Later, I looked at paragraphs 28 to 31, just so you know,
Yes.
in which it was made clear that the tribunal is not expected to go trawl through the papers to identify points or potential issues, and may rely on the parties as having identified the issues that need to be addressed.
Yeah.
And if you look at the new guidance that has been issued by the current senior president of tribunals, it talks about ensuring that the parties conduct proceedings with procedural rigour. It's the parties who are on obligation to conduct proceedings with procedural rigour. And yet we all know the terms of the overriding objective, which were referred to in the guidance, without delay. And I think some of your submissions you've identified would cause delay. Allotting to cases the appropriate amount of time might require cases to be allotted more time. So I think there's a range of other considerations that might be relevant to the broad nature of the submission you're making, speaking for myself.
So a judge is certainly not expected to trawl through documents to ascertain what the issues are. The parties should identify an issue, entirely accept that. In this case, there was a failure, entirely accept, to identify what was an obvious issue by the Secretary of State. There's no hiding from that fact. But where a case of this sort differs from a case of LATA, the cases like LATA, is that a judge here knows what the issues are because Parliament has identified those issues in the statute. Whether someone has been here lawfully for half of his life, whether a return would lead to, whether there are very significant obstacles to relocation, whether a person is culturally, socially integrated in the UK, unduly harsh test, etc. So the Parliament has identified those issues, and the obligation of the judge, on a judge, is to address those questions. If there is a concession, then so be it. A judge would record that there is a concession, make a finding, and make the assessment on that basis. But failure to address the question would be an error of law.
Thank you.
My Lord, well, this of course, all this debate concerns the first ground of appeal.
Yes.
The second ground of appeal is
And assumes that you're going to get leave for it.
What?
Assumes you're going to get leave to advance ground 1.
Yes, I will address that question shortly. Ground 2, of course, is that the judge erred as to the very compelling circumstances assessment. So may I take you to two authorities of this court where Hirtie Iraq was considered, and the court explained what the phrase over and above actually entails. The first of two authorities is Kapenyaka, tab 38 of the bundle. So this is a case involving a serious offender where section 117C6 applies. This is the judgment where this court considered judgment of this court that followed Hirtie in Iraq in a case called Yalchan. And I will not take you to Yalchan, my learned friends may, but the reason being that Yalchan is considered within this judgment. And go to page 711 you will see a heading just above paragraph 25, NA Pakistan, Hirtie, Iraq and Yalchin. And under that heading, the Vice President discusses those authorities, cites the paragraphs in Hirtie, Iraq that I've taken you to. And the conclusion on law appears at paragraph 41 as to what the phrase full proportionality assessment entails. Lord Hemblin's judgment should not be read out of context. The reference to the need for a full proportionality assessment does not meet the question in a case as present is simply whether deportation of foreign offender would be disproportionate in a general sense. This is an error that I shall submit that this tribunal made. So there is no general assessment of proportionality, but whether...
I'm very sorry, I've only got as far as paragraph 36. Which paragraph you want?
Paragraph 41.
41, thank you.
So 41 is the conclusion on law.
I have it, thank you.
So it does not mean assessment of proportionality in a general sense, but whether the criteria in section 117 C6 is satisfied.
Yes.
And then paragraph 42, the test isn't very compelling circumstances. The test is very compelling circumstances over and above the two exceptions. If exceptions do not apply, this case, that does not give the first-tier tribunal a general license to bypass exceptions 1 and exception 2 and go straight to considering very compelling circumstances. So even where there isn't a sort of private life claim, a judge must look at exception 1 because that will inform the judge as to how to approach the question of very compelling circumstances. So judge must consider, even where there is no private life claim, for how long the person has been in the UK, whether the person is culturally and socially integrated, and whether there are very significant obstacles to integration. Precisely in the same way, a judge must consider whether the effect of deportation would be unduly harsh under subsection 5, even where the exception does not apply, because that would inform the assessment under subsection 6. And what it actually entails is set out at paragraph 43. Something more is required than under exceptions 1 or 2. And what it actually entails is an unduly standard. So if there is a finding that effect of deportation would be unduly harsh, that's not enough in a case of this nature. A judge must consider whether there is something unduly harsh, something more than exception. So what that in my submission means is that under subsection 5, harsh is an elevated standard. The addition of the word unduly raises the already elevated threshold even higher. And what is required under subsection 6 is something more than unduly harsh.
Something more than would have satisfied the exceptions, because very frequently, as in our case, the exceptions are not satisfied because of a non-qualifying partner or non-qualifying children. So the over and above is over and above what would have satisfied an exception.
Yes.
And that would apply both to a less than 4-year
Yes.
person or a 4-year plus person.
Yes.
Okay.
So if you're a medium offender with a sentence of less than 4 years, and if you meet the elevated standard of unduly harsh, you succeed in the articulate appeal. That's the end of the assessment. But if you're not a person to whom subsection 5 applies,
Or if you can't satisfy the exception for any reason.
for any reason, precisely, you can then only succeed if, in a case of this sort, you demonstrate that the effect of deportation would be unduly harsh, and then that it would be unduly harsh. There is something more than undue harshness.
I find the unduly tricky. Can I just make sure I've understood your submission?
Yes.
If you're looking at a decision that has to be made under applying subsection 6 or subparagraph 6, subsection 6, you've got to have something which is over and above what would have qualified for exception 1 or exception 2.
Yeah. Yes.
Albeit that you may well be doing it in circumstances where the person couldn't satisfy exception 1 or exception 2. And so in that sense is somewhat on the back foot before they start.
Yes.
Okay,
Yes.
thank you.
So two propositions of law arise from Kapaniaka. The first is that there is no sort of general proportionality assessment. The question, and Hirtie ought not to be read as an authority that full proportionality assessment means a conventional proportionality assessment where a judge sort of goes straight to subsection 6 and conducts a proportionality assessment. The second point is that over and above means, as Milord has said, something more than what would have been sufficient under exception 1 or exception 2. Something that is unduly harsh. So this is Kapaniaka. Those words over and above were considered again by this court in a case called Majira. The next authority in the bundle, tab 39, page 722. So that is a case where the tribunal dealt with section 117C 6. You'll see that it involved a person who is a serious offender who could not succeed simply by relying on exceptions. And may I ask you respectfully to look at paragraph 11, where a conclusion appears as to the words over and above. So those words are of significance. Over and above means that a person who is a serious offender, or where exceptions do not apply, must not only establish circumstances relating to private or family life that provides a basis for concluding that deportation would involve a disproportionate interference with Article 8 rights, which is very strong indeed. The circumstances must also be compelling to a degree that goes well beyond anything that does or would fall within either of the exceptions, that the point that Milord you were just making. So the standard to pick the words that are used in the legislation is either unduly harsh or something that is well beyond.
I think there's a difference between what I was putting to you and what is said at the end of this paragraph. Because I was not saying anything that does or would fall within I was saying anything that would satisfy the exceptions. One or other of the exceptions.
Yes,
which I think is different, but it may not matter.
Yes, with respect, I'm not sure if that is different. What I think with respect that the court was saying here is really the point, my lord, that you made, which I accept and adopt. So where exceptions do not apply because we have a serious offender or there is no qualifying child or qualifying partner, meeting exceptions is not enough. So the test, the ultimate test is unduly harsh, or whether there's something that goes well beyond what is required.
But, yes, go on, sorry.
Yes.
It's both ways. The fact that you may satisfy the exceptions isn't enough. The fact that you can't satisfy the exceptions doesn't mean that you won't be able to satisfy very compelling circumstances.
I agree, yes.
Because it depends on the circumstances.
Yes. But if exceptions do not apply, then it is an error of law in my submission for a judge to simply go to Art subsection 6 directly and to conduct a proportionality assessment. Even where exceptions do not apply, a judge must work through the two exceptions, make relevant findings, and then ask the ultimate question as to whether there is something over and above those exceptions.
I thought there was authority to the opposite proposition. You don't have to go through exceptions 1 and 2.
So that, my lord, was well, arguably Yelchin.
Yes.
And, well, yes. So this is what the court arguably said in Yelchin.
You don't have to.
Yes, but court in Kapenieka considered precisely that point and said that, well, you do, and Yelchin wasn't saying that is the case.
You need to be careful with it, Yelchin. It isn't saying you don't need to do it. What it's saying is when you come back to the 116 exercise, 1176 exercise, you don't have to do it again, provided that it's clear from what you've already done that you've found the facts and you've looked at the exceptions when dealing with your 1176 thing. Yeltsin wasn't saying you can throw it out of the window. It's simply saying, I can't say you've got to repeat it, but you do have to show you've done it. Or it has to be clear from the judgment as how they've done it.
Indeed, that's why I use the word arguable. I mean, one reading of Yelchin was that there wasn't a need for the tribunal to go through that, but this court in Kapenieka made it absolutely clear that the position, Malone, is as you've just summarized.
Because quoting the difficult to pronounce this, Kapenieka was bound by Yelchin, and we are bound by Yelchin.
Indeed.
So they can't say, oh, we don't like Yelchin, we're going to do something else.
Yeah.
Under our law, we have to apply Yelchin.
Precisely. So in both,
This is what it means, not whether we like it.
both in Kapenieka and Majira, this court considered Yelchin and said that, well, this is what Yelchin means, that particular paragraph. So I haven't taken you to Yelchin for that reason. In my submission, the position is set out correctly in Kapenieka and Majira. These are my submissions on law. May I then turn to the facts of this case and address you on the two grounds. So if you have the code bundle in Hirtie, the first document that I will take you to is the Secretary of State's decision. You have that decision at page 78 of the bundle. So the Secretary of State sets out the uncontroversial immigration history, criminal history, and then at paragraph 14 says that Article 8 does not give a person an automatic right to choose to pursue their private or family life in the country of their choice. So you must read. You will read this decision as a whole. There's no hiding from the fact that the Secretary of State did not say in that decision that well, relocation would not be unduly harsh. There's no hiding from it, so I have to do best with what I have. And I will take you to the parts of the decision that I say are relevant and support the position that I'm seeking to put forward. So the first is paragraph 14. This is the context in which, in my submission, you'll read the remaining paragraph. Now, at paragraph 15, the Secretary of State says categorically that, well, I have made rules, and Parliament's view is set out in section 117A to D of the 2002 Act. And that provides the framework. The nature of the Article 8 claim is considered in summary at paragraph 17. You'll see that the Secretary of State noted that they all had limited leave to remain until 2026. There's no qualifying child, there's no qualifying partner, and there are, and that is the case. Paragraph 19, well, in accordance with the immigration rules, unless an exception applies, deportation would be in the public interest. And that is the same exception as in the statute.
Is there, this decision is all done on the terms of the immigration rules, as you said. Is there any distinction at all? Will you deal with that?
Yes, I will show you the rules as quoted in the decision. There isn't a material distinction.
I mean, I had understood that it makes no difference whether...
It makes no difference.
No, thank you.
But what one gets from paragraph 19 is the Secretary of State saying that unless exceptions apply, your deportation would be in the public interest. You then have a heading, family life with children. And if you look at the exception, it is quoted at paragraph 25. So the exception applies where there is a relationship that is genuine and subsisting. And I do ask my lords to take a note of the word "and" as it appears at the end of each of the each of the four limbs of the exception. A child is a British citizen. At the date of the application, the child is in the UK. It would be unduly harsh for the child to live in the country to which the foreign national is being deported. And it would be unduly harsh for the child to stay in the UK without the foreign national who is to be deported. The Secretary of State says that, well, these are the 5 limbs of the exception. And if the exception does not apply, then the public interest would require your deportation. Paragraph 28, the Secretary of State says that, well, it is not accepted that it would be unduly harsh in the event that you, Mr. Hirtie, is deported. Then is the sentence that it is not expected that the child would leave the UK in the event of your deportation. The decision maker took the view that the child has leave to remain until 2026, and it is not expected that the child would leave. What the decision, and that in my submission is a perfectly rational, cogent point to make. What the decision maker completely accepts should have done is to add a sentence to the effect that although it is not expected that they would leave, it would not be unduly harsh for them to go.
Well, we don't know whether she thinks that or not, though. If she hasn't said it, there might be reasons why the child can't be expected to go. It might be in the middle of treatment at a hospital. You just don't know, do you?
I see that. So I accept that, and this was not. I mean, this as I said, there is no hiding from the fact that this isn't said in the decision. But there is no concession that relocation would be unduly harsh. And the Secretary of State took the view that that wasn't really relevant because she had already made a decision that...
Where do you get this from? That the Secretary of State didn't think it was relevant?
My submission from paragraph 28. The Secretary of State said that, well, it wouldn't be unduly harsh. Separation wouldn't be unduly harsh.
As you so rightly said a minute ago, if there was to be an issue about it, there should have been a sentence which says, but the Secretary of State does not consider it would be unduly harsh if he had to go or chose to go.
So that sentence I accept is of course missing.
But what I was picking up on is your assertion that the Secretary of State didn't think it was relevant.
So that, in my submission, that comes from paragraph 28 for this reason. If separation is not unduly harsh, then the question of whether relocation is unduly harsh is an academic question. It does not arise, it's not relevant. Because if separation will not lead to unduly harsh consequences, the answer to the question posed by subsection 5 is no. So in other words, if the Secretary of State decides that separation would not be unduly harsh, that's the end of the assessment on one view. There is no need for the Secretary of State or the decision maker to consider the alternative. The alternative would only arise if the answer to the first question is in the affirmative.
I understand that, but the problem is when you get to the tribunal, there's another stage. When they say, no, it is unduly harsh, we can't separate the family because the wife would crumble, she can't cope. Then the Secretary of State, that's the part at which he's got to say, well, in that case, another issue arises. If I'm wrong on the effect on the family if they're separated, it doesn't matter because I'm going to exercise my powers, which she's got, to deport the whole family under section 3.5, and that wouldn't be unduly harsh.
No.
But he would be doing a number of things. Firstly, he would be changing the legal position of 3 people. They're allowed to stay till 2026, and he'd be saying, no, I'm deporting you.
No, Lord. That with respect isn't the correct analysis. There is no power to deport family members in the sense that.
But that 3.5 gave you power.
No, but in so if my Lord, someone has leave to remain under EUSS, it's not possible for the Secretary of State to simply deport that person. The Secretary of State was not contemplating deporting the family members at all. So in a case of this nature, what the Secretary of State should have said was that I'm not expecting the children to go because they have leave to remain, but I do not consider that that their relocation would be unduly harsh. So in other words, it's a matter of choice for them. Now, so the Secretary of State's primary case was that separation would not be unduly harsh. She was wrong on that. She was wrong on that primary point. And the tribunal held that Secretary of State was wrong. So once the tribunal reached that stage and took the view that the Secretary of State was wrong, there is then an obligation in my submission on the tribunal to consider the consequential question, the second question that arises.
Or like Borges.
Like Borges, precisely. So in Borges, the Secretary of State applied the lower threshold and said that, well, for that reason, I'm deporting you without considering the imperative grounds. The tribunal held that the Secretary of State was wrong. The tribunal then said in a sentence that there are no imperative grounds and I allow the appeal. And this court said that once you reach that stage, once you've decided that the Secretary of State is wrong, you then must consider the second question that the legislation requires you to consider. So this is where in my submission Borges applies. If you look at paragraph 31, after considering all the matters, the Secretary of State said, well, having considered all available information, it is not accepted that you meet the requirements of the exception to deportation on the basis of family life with a child. And what are those requirements? Those are the requirements at paragraph 25.
Yes, but really, what it follows after all the other paragraphs, which say it wouldn't be unduly harsh for you to stay here for these reasons, wouldn't be unduly harsh for the other child to stay here, and when it's referring to all the available information, it's pretty clear, isn't it? It wasn't remotely dealing with the go. It was only based on the staying but separate.
Yeah. So the Secretary of State, accept that, of course. The Secretary of State stopped at the third or fourth question. But she is saying that this is the exception, and you do not meet that exception. She was wrong. And well, subject to second ground, she was wrong. So once the tribunal reaches the stage where the tribunal concludes that the Secretary of State is wrong, the question is what is then the obligation of the tribunal to do so?
Have I noted your submission correctly? If this is what you're saying about 28, if separation is not unduly harsh, then relocation is not relevant, as the finding that the separation is not unduly harsh is sufficient to lead to the conclusion that very compelling circumstances cannot be made out.
Absolutely.
Am I right at the end? Is lead to the conclusion that very compelling circumstances cannot be made out?
Yes, because you would then not satisfy the exception. And if you don't satisfy the exception, it's not possible for you to show that there is something over and above the exception that meets the very compelling circumstances test. I mean,
I don't at the moment see how making that limited finding, that separation, because relocation may involve different questions to the simple question of separation.
Yes.
Because it's part of your case. It may involve family structures in Romania, prospects for employment in Romania. So I'm just, at the moment, well, I'm thinking out loud, if I'm thinking at all, at the moment I'm not sure that your proposition, which I've just read back to you, holds good.
Yeah, so, yes, so the position in my submission is that if separation is not unduly harsh, then there is no need for the decision maker to consider whether relocation would or wouldn't be unduly harsh. And that would answer subsection 5 question. When one goes to subsection 6, a judge would say that I have already decided that separation is not unduly harsh. I've already answered the question under subsection 5.
There's nothing more other than separation, and therefore...
And there's nothing more than that. So this is what a judge would... I mean, if I may ask my lords to test the argument in this way, just looking at paragraph 25 of this decision, you have 5 limbs of the test. Assume the Secretary of State would have said, in a sentence, that I don't believe the relationship is genuine and subsisting, full stop. And I find that exception that is not met for that reason, and has said nothing about other 4 limbs. The person brings an appeal to the tribunal, produces evidence of relationship with the child. A judge finds that there is a genuine and subsisting relationship. Is it then appropriate for the judge to say that, well, there is genuine and subsisting relationship, and I allow the appeal, because the Secretary of State has said nothing about other limbs?
Where I think this argument may fall down is what we were discussing about 20 minutes ago, the fact that one of the one of the criteria for the exception is not there only increases the importance of assessing very compelling circumstances, and relocation, because it raises different issues, necessarily needs to be considered if it's to be part of the decision-making process. So I don't think you can just, at the moment, I'm not persuaded you can just exclude, say that, as it were, Borges. You can't just say, well, because I found one route through, I'm not going to consider anything else. Because relocation raises different issues.
But so does, in my submission, separation. So
she said separation. You don't qualify for the exception because I find that separation would be okay.
Yes, but if the Secretary of State...
That's E.
Yes, but what if the Secretary of State has said nothing about either separation or relocation?
That would be different. Then it would be an issue. We wouldn't be giving you such a hard time if the Secretary of State had said any of that.
Now then, Lord, the Secretary of State wouldn't have said that because she took the view that there is no genuine and subsisting relationship, full stop, and I'm not considering other matters. How is that different in substance? I respectfully invite Lords to consider from a scenario where the Secretary of State stops the analysis at the separation point, says that separation is not unduly harsh.
Well, for these purposes, you agree that the decision letter doesn't raise relocation.
Yes, but I submit that that's not fatal.
I understand that, but that's. I think just looking at the time, we need. Can you go through the rest of this letter?
Yes. So I accept that it does not expressly deal with relocation.
Yes.
But I do place reliance on paragraph 31. At that paragraph, the Secretary of State said that I do not accept that you meet the requirements of exception to deportation. And those requirements are at paragraph 25, which includes separation and relocation. So there is no reasoning by the Secretary of State as to why relocation wouldn't be unduly harsh.
But she did, as a matter of fact, consider B, which on your argument was unnecessary, irrelevant.
That the child is not a British citizen, hasn't lived in the UK.
She does consider that.
Yes, and so does she consider the other point. Where she stops, of course, is at the second label of being unduly harsh.
Okay.
Yes.
And it's the same pattern when you come to the next section.
Yes. So paragraph 31, you have seen. Paragraph 33 is where the Secretary of State sets out the exception. And at 38 says that it is not accepted that you meet the requirements of the exception to deportation on the basis of friendly life with a partner. Secretary of State did not say, I accept that relocation would be unduly harsh. The reason for that in my submission is that the Secretary of State has said that separation would not be unduly harsh, paragraph 37. She was wrong. Once the judge decided that she was wrong, the judge was then obliged to consider the question of relocation.
The difficulty, sorry, I'm just going to go once more to this because I think it's quite important. With family life of the partner, the Secretary of State, despite your argument, addressed B and held that she's not settled in the UK.
Yes.
Which on your argument was unnecessary.
Yes.
But on your argument, it's in exactly the same category as relocation. Because it's a reason why the exception is not satisfied.
But not in my submission, exactly in the same situation, because
She could have looked
Yes.
at A and said you tick, B, you don't satisfy that, therefore you don't meet the exception, full stop. But she doesn't.
Yes, she makes a finding about separation not being unduly harsh. Now I do, I mean, of course, this is a letter that isn't written by a lawyer. It's written by a Home Office decision maker, and if one, in my respectful submission, stands back and looks at this case, it is, in my submission, absolutely clear that this is a case where relocation would not be unduly harsh.
But the problem that I've got is not so much the decision letter, she dodges it, but having got an appeal to the FTT saying she's wrong, it is impossible to separate us.
She didn't.
Then the Secretary of State,
Basically.
that's when she says, well, there is another issue, which is relocation. Although I didn't deal with it, I'm satisfied that the 4-year-old can go to school in Romania, the 1-year-old will go to kindergarten in Romania, and the mother will have to cope with Romania rather than England. And she didn't do that at the review stage.
No, because at review, there wasn't a review.
No, but there was a review, but she didn't put it in.
Yes, no, she didn't.
Yeah,
But there was a hearing at the tribunal.
yeah.
Secretary of State's case was that separation would not be unduly harsh. The tribunal disagreed and said that separation would be unduly harsh.
But she never said, and if I'm wrong about that,
No, she did not.
relocation. She didn't say it in the letter, she didn't say it in the review document, and it doesn't seem to be an argument that she raised before the tribunal. And
Yes.
what you're saying is, despite 3 goes, she still wins because the tribunal should have guessed that that thing, of all things, would be the thing that needed to be determined. That seems to be what you're saying.
No, but that isn't, my lord, in fact, a point that is just hidden somewhere in the papers that a judge has to trawl through to identify. This is an issue that is set out in the primary legislation, in the immigration rules. Secretary of State says in the decision that the requirements of the exceptions are not met.
You don't have the rules in the bundle, and my feeling Gillespie doesn't have them in this form. It'd be quite helpful to have the practice direction that applies to the tribunals and also the relevant rules that apply.
Yes, Lord, the relevant rules are set out in full in the Secretary of State's decision. So these are the rules that I've taken.
Provided the practice
So
direction.
practice direction is in the bundle.
Or was it?
Is
It's
it?
in a supplementary authorities bundle.
Oh, the new bundle. I haven't looked at the new bundle
No,
yet.
that's fine.
So it's tab 1 of the authorities bundle.
Sorry, tab.
So tab 1 of the supplementary
Oh, yes,
authorities
it's
bundle.
there, yeah.
But this says is uncontroversial. There is a need for procedural rigor, subject to the Robinson obvious point, which is at paragraph 1.3. And there is also need to comply with this practice direction. And the fact that the Secretary of State failed to comply with the practice direction to carry out a review can be relevant in terms of the issue of costs in other matters, but in my submission does not defeat the argument that I'm seeking to put forward. And for these reasons, when one reaches this stage of the analysis, the case in my submission is quite similar to Borges. Finally, page 85 of the bundle, where the very compelling circumstances test is considered. There is a heading, other very compelling circumstances. And the Secretary of State says, this is paragraph 49, that the appellant can, Mr. Hirtie can build a new life in Romania. For the reasons set out above, it is not accepted that the circumstances are very compelling over and above. And the reasons that are given earlier include the reason that the exceptions, the requirements in the exceptions are not met. So this is the Secretary's decision. The decision of the First-tier Tribunal is at page 92.
Before we get, looking at the time, should we stop there?
Yes, if that is convenient. Yes.
Can I just, how much longer do you think you'll be?
Lord, another 30 minutes, I'm afraid.
No?
But so that you know, Lord, I have made my submissions on law.
Right.
So of course there will be no duplication.
Okay.
When you hear the other.
Thank you very much. So we'll start again at 2 o'clock.
All rise in favor.